I'm Lewis Hatcher. I'm a litigator with the law firm of Watson Spence, primarily litigating in federal court, and I have a concentration of my practice in employment law. I do mostly defense, a little bit of plaintiff employment law as well. It is very expensive to defend lawsuits filed by employees in the federal arena under Title VII or Section 1981 or 83, what we call discrimination lawsuits or harassment lawsuits. Extremely expensive to defend, and employers, if they lose those lawsuits, have to pay not only the judgment or award, they have to pay the plaintiff's attorney's fees as well, and that can be very substantial. The best defense against employment lawsuits, first of all, the very best defense against an employment lawsuit is to have employees who know how to treat each other and treat each other with dignity and respect. But to accomplish that sometimes, and it's always a good idea to implement a training program, strong training program with your company so that your employees do know what is expected of them in the workplace and what conduct is prohibited or will not be tolerated by the employer. When choosing a trainer, it's important that you get someone that the employees will listen to and that they will respect. It would not be a good idea, in my humble opinion, to, for example, hire a young lawyer out of a large Atlanta law firm who would come down, talk to employees who are twice that person's age or 3 times their age, and rattle on about what you cannot do in the workplace. I say this from the standpoint, I've been on the other side. I was a licensed electrician before I became a lawyer. I was also a warehouseman. And I know what it's like to listen to some lawyer come in and tell you what you can't do in the workplace, and you know that they've never been in the workplace and they can't understand what daily life is like. So you need to get somebody that can go in and talk to these folks and have them respect you and have them listen to you. And then the trainer needs to give them not only what they cannot do in the workplace under federal law, but give them some examples of what they can do. In other words, you can still enjoy going to work. You can still enjoy socializing with the people with whom you work. You can still compliment people, and you can do the kinds of things that we find in society to be acceptable and good things. There's simply certain behaviors that are prohibited. And depending on a person's background and depending on the particular industry and the history and traditions of that particular industry, there may be conduct that is now forbidden by federal law, which in that particular industry or from that particular person's background, they would not realize that that's prohibited conduct. And that's the kind of thing that you need to do with a good training program. A good training program will also protect the employer, because in cases involving pure harassment, not where a person's terminated from employment or demoted, for example, but where they're harassed by what they call a hostile work environment, an employer can defend on the basis that they have a strong policy against the harassment, that they've implemented training programs, that they've disseminated the policies and procedures for reporting misconduct, and that the employee has been encouraged to come forward with complaints of harassment. And if the employer does that, and if complaints do come forward, the employer addresses them promptly and effectively, then the employer can defend itself against liability in most of those cases. If anyone would like further information on how to implement a training program or what should be part of that program, I'd love to help. My email address is lhatcher@watsonspence.com. My phone number is 229-436-1573. Thank you.